growth of the brain, then it is very different from a child's brain and an adult's brain. Our problem is with semantics, because certainly adolescents are not child in that sense, but they come with the definition of child is yes. And we're happy to use that term because child evokes a lot more love and affection in our mind than an adolescent is. Both of us have been parents and have adolescent children, so it was a very different age. They don't listen, they don't do it. And therefore, making that division is not particularly beneficial for children to be born as adolescent and children. But we know that the brain science says that adolescents actually have a different brain. And there are three very important significant changes which happen at that point of time. The part of the brain which allows us or which motivates us to take decisions, take sexual pleasure, and do things which will give us a lot of happiness and kicks. That part is very developed in the brain, but the other part, the CO which controls these impulses, is not very developed. It's not there to control them. And what has been also found that they act in that manner is this desire for and this the motivation for rewards, the risk-taking behavior, fast driving, sexual experiments. It all happens much faster when they are in the company kids. And you would have noticed that as what it is, even in India, children of this age group do not come into offences alone. Either they will be in their own age group, all of them are juveniles, or they will be with us. They don't commit serious offences alone because the very nature of their development of the brain at that point of time makes them take risky behavior when they are in the top of each other. They dare each other, they make bets of all kinds, and all kinds of things happen. And some of us can recollect our adolescence. When we did lots of things, we knew were wrong, but we still did them. And we did them, and because of the generation gap, our parents don't understand us. Parents are the same thing. But there's a lot of responsibility here also, not only the parents' responsibility, but all this scientific information wasn't available when America went into 1995 to 65. Today we have this information, and because of this, America has started rolling back the system. There are more information about this. So America in 2005 abolished death penalty on the basis of the findings of the research. It has in 2011 brought it back. Children in America would also be sent to life imprisonment without parole, which now we have proposed. We have not proposed for that children, but we have now proposed for that. We never had that before, but now it does require it. That also got abolished first for offences which were non-homicidal, public or homicidal offences, which do not involve killing somebody. But then they extended it in 2012 to all offences that no child can be sent there. Now, federal government in America is telling the states that it will not release federal funds if the states are sending their children to prison. So they are actually pressurizing because the juvenile justice system in America is a federal system. State governments make the law. The center cannot give a directive as we are doing here in India. Therefore, they are creating supportive measures to promote non-sending of children to the federal prison. And it is happening because they found that sending the children to prison, when they did the statistics of how have they faring after the release, they found that the adults sent to prison, I think there will be some slide which will come out of New York Times, which is reporting that children who were sent to the adult system are actually committing more offences than those children who were not sent to the adult system. So after 30 years of their experience, they have come to a conclusion that they made a mistake in the 90s in excluding children. We want to do that, copy them in 1995 and not look at them today as to what they want to do today. And it is no country in the world which has reported that by sending children to the adult system, they have reformed children. They have replaced the juvenile delinquency. So no success stories are coming from any part of the world by sending children to the adult system. The only success stories are when children were put into information, in protection, given an opportunity to start again. So we don't want to learn from these experiences of 30 years of these other countries where they want to let go. They still have a lower rate. Yes, they have lower age, but they are working towards increasing their age. They are moving in a opposite direction than the direction we are moving. Then we say, juvenile are being used by others for commission of crime and they will not be punished. So we are saying because they are being victimized, so we will do nothing to the victimizer, we will punish them. For me, this has been, this is an argument which I have heard much before. In any police station I have gone to, the adults exploit them, and therefore they must be punished. I say you can make a law saying that the adult will be given double the punishment if they are found to be committing offence with a child. I can understand that. But to say because they are being exploited by adults, therefore they should be punished to protect them from the adult exploitation, for me that makes no sense, but I have heard this argument continuously for the last 2 years. It's not new today. And they are telling me today again also. Juvenile crime is on the rise. I wanted to show you as a pictorial presentation that it's just in slides about the total crime in India. But I remember my data that when you look at the data, the rate of crime, I told you it is 3 in India. So out of the total number of children, it is 3. When you look at contribution of offences by children to total crime in India, what do you think? How many children come in? If suppose there were 100 crimes in India, how many crimes are committed by children? There's some guess, it is 3 out of 1 lakh. It has to be very small, but how small is that? How small is the small that I'm talking about?
0.01.
Slightly more than that, 1.2. It started at we have got data from many number of years on juvenile delinquency, but because the rate has changed. But even today, it is 1.2 of the total crime in India. So 1.2 is the total crime by children, 40,000 are constituting only 1.2% of total crime, and merely 1,300 or so of them are in the age of 16 to 18, committing offences, serious offences like rape and murder. So out of 40 crore children and 1.2 billion population, we have about 1,300 children. So we are really looking up, and these are not the category called heinous or the most rarest of the rare murder or the most energetic form of rape. It is just any category of rape and murder. And so I skip this slide because these are not making much sense. So we have to proceed to useful. But when you look at the educational and the economic background, what we find is that the majority of the children, again I'm sorry that we can't see these slides here properly, the largest number of children who are found to be committing offences are children who have done the primary and are out of the school. So they can continue, and dropping out of the school with little education has contributed heavily. When we did not have this 100% involvement-free primary education, our uneducated group used to be the largest chunk in it. Up to the, like I said, involvement of 100%, dropout is not still much out. So that's the largest chunk, and it is the lowest economic strata. It is not that children from other strata are not committing offences, but they are not getting picked up. These are the really poor and the school dropouts which are getting into this neck of the children. These are the children who will be sent to the legal system, will be from there. Not our children, even if they commit the most innocent things. Because we have lots of resources. The children we are actually going to deal with would not have any other resources. So, increase in rape cases in 2013 over 2012 have been 60% for young offenders, for children. That's a very, very high increase. We must be worried about it. But then we look at the report by Hindu and we find that 45% of them are love affairs. Adolescents who are having a love affair and are into relationships. And this has happened because the law changed. Law changed in two respects from 2002 to 2013. One is POCSO, Protection of Children Against Sexual Offences Act. Before POCSO, the age of consent for sexual intercourse was 16. It was raised to 18 by POCSO. So if a girl of 17 was having an affair and the parents did not like it, the parents would file a complaint of kidnapping but not of rape. But after POCSO, they filed both the complaints of rape and kidnapping. Because in case of kidnapping, the age was 18 under IPC. fact the age for sexual intercourse was 16. It all became 18, and therefore 45% of these cases are falling that category, where it's usually the parents of the girls who are filing these complaints of rape, and the static shows rape because now the definition of rape is. So that's one difference which has happened. The other difference has happened in the definition of rape itself also. Previously it was only penile, vaginal intercourse, which was in the category of rape. A man having penetrated the vagina of the woman with a penis only was the category which was rape. But today it is object, it is anal, it is body parts other than penis, finger rape. All these particular huge range of categories are included in the definition, right? And in case of children, it is gender neutral. In case of adults, it remains gender, that it is only the man who does penetration of the women or orifices in different manners. That is the only difference. But in case of children, it can be man to man, boy to boy, boy to girl, girl to girl. Any of these categories will fall, and therefore, 60% increase is a lot more attributable to the writing of the net of the law rather than necessarily the incidents. And certainly with the organization, Delhi is on the very, very high rise on these offences. And any judicial training I go to, there is primary concern is love cases. How to handle love cases? Because previously, in the love cases, they were using the clause in IPC which says less than the mandatory minimum of 7 years to be given for special reasons. So the consent in those cases also did not matter below the age of 16. But today there is no exception. So if there is a love affair and the boy was 19, the man was 19 and the girl was 17, this man has to go for a minimum 7 years of imprisonment. And if it is repeated in the law, he goes for minimum 10 years of imprisonment. There is a lot more discretion in the matter. So certainly we need to understand that this whole, even the data which is showing us an increase, the reasons for it are also somewhere, some other factors have contributed to the increase. And not because children have gone better and started molesting every girl on the road and every child on the road is a fish to us. When there's a child on the road, look at how the roads are done to the police. They've heard of e-rickshaw menace for a long time. Before this final law, when this child in the lap of a woman fell into the boiling pit, the whole story came out. Remember the story, how was this particular incident presented? That it was a juvenile who was driving this rickshaw and he had been out on bail for an offence. In how many other e-rickshaw incidents you found the history of the person there? Driving the e-rickshaw at that time was nothing illegal. So whatever he was doing was nothing illegal. He was not violating the conditions of his bail. And therefore all this information was only thrown into the media to create this whole panic that look, children are released on bail, then they keep on committing more harm. We do not blame the road for being smooth. Why about this mid-boiling committed on the footpath? All these questions are not raised. The focus is on the juvenile driving that case. And this keeps on happening, doing whitewashing in our minds. So America, some figures are there which I've already quoted, so I can very quickly go on to the next slide. So we have 10 to 17 years at a increase of 8,476 in 1996, and this is the delinquency rate, which is the violent delinquency rate. The general delinquency was 1400 plus. And even the existing crime rate of more than 500, despite the exclusion of as young as 13, there is any case going for change of this approach to legalization. This is the New York Times that I was referring to. Teenagers prosecuted adult for 2 time in adult jails, their first in life, and go on to commit more violent crimes than those who are handled by the juvenile justice system. This has argued for steering adolescents into the juvenile justice system, where they can receive rehabilitation services and be spared adult conditions that banish them to Islamic parties and lead to personally possible choice. After a 17-year-old, this boy was sent to prison for 7 years. He will be out in 2024. And then what does it do? How many of us will delete his reform? Even if his reform, the government itself doesn't delete his reform. It will never give him a job. Why would the government expect us to give him a job? Why would the government expect us to marry our daughters, and why would it allow our children to do certain things? So what is the remaining 50 years of his life going to be, if not the life of his life? Pushing him there, even though he might have been in this because of the circumstances in the country itself. Very quickly I'm coming, because I got a lot of problem with the bill, but this audience is not law students, and it is not law professors also. And therefore I will very quickly point out on the drafting category also, so many mistakes. Drafting, mistakes can be taken care of, but I think the policy shift which has happened is the more crucial one, and that's why I wanted to spend more time on challenging ourselves to find out whether what newspapers are making is the correct beginning and ask for. We have now the new bill has this principle of innocence, presumption of innocence. And I'm not sure some of you would know that presumption of innocence has always meant that you are presumed to be innocent till you believe. But that's not the principle of innocence under this law. This law says that there is a presumption of innocence of mera-fide or wrongful intention till the age of 18 years. And in criminal law, criminal liability cannot be imposed on a person if this person does not have the capacity of wrongful intention. And therefore, the whole JNU decision goes out. And this is in complete contrast to what they are saying in subsequent provisions. So, government doesn't know what it is doing. One section of the law says, now we have raised the criminal responsibility age to 18 by this presumption of innocence. While IPC says 7 and 12. So, one section will say no punishments whatsoever because if they do not have the criminal capacity to have criminal intentions, certainly they cannot be convicted of an offence. And then it goes on to exclude children from the system. Then we have violation of Article 20, the fundamental rights also suspended. We are in such a dire state of emergency that procedures need not be followed, fundamental need not be respected, fundamental rights need not be respected. There is one of this provision which says that if on the date of arrest, the person is above the age of 20 and is arrested for an offence which is committed before the age of 18. If you can presume by this provision that he was an adult, this offence has been committed by an adult. In Article 20, which says that no person can be given punishment more than the one which is applicable on the date of offence. So what we are saying now is that you have a duty to surrender before the court if you are suspect. If you do not surrender and police reaches you after 3 years or 4 years, then you will be dealt with as an adult offender. It is like saying that, okay, if any one of us adults commit an offence today, and for 3 years we do not surrender or we are not found by the police, we will be given double the punishment to us. So we are getting our duty to surrender, which has never been part of criminal law, on part of every suspect and accused. And it certainly started from violation of Article 20. It is also in violation of a very long part of judicial decisions. Right from 1983, clearly delegated before the Supreme Court, and constitutional benches twice have said this. 5-judge bench of the Supreme Court have said that Article 20 will be violated if you say that, because in Adita, this is what 2-judge bench of the Supreme Court said, that age on the date of production will determine age. That has been set aside by a high judge and saying it is unconstitutional. Let's say going ahead with it. And a corrigendum has been issued after the raised this objection of the Supreme Court, saying equity perspective. It can be of any use only if Article 20 is amended. Without amending Article 20 to make this law, because Article 20 is categorical that in punishment applicable on the date of offence. So whatever is the legal order applicable on that day. So if there are 2 children who commit offence, one is arrested on that same day. If it goes through the juvenile justice system, the other has to go also. Article 14 also is there of safeguarding. But no fundamental rights are in suspension because there is an emergency created by juveniles. Juveniles will be transferred to a children court. Above stated how many offences which are punishable. criminal court is dealing with adults who have committed offences against children. And the policy of the law is that any adult who commits an offence against children should be punished more harshly. Session court has got an equal responsibility to punish as well as reform by punish. So therefore they can release people on probation, they can give sentences which are useful for their information. But these courts are geared towards giving mandatory minimum sentences, harsh punishments. So these are the courts. It is not only children's court but also the Foxco court, also premises session court having jurisdiction. So if it is a simple murder case, if a child has committed offence, has killed an adult, for example, then it is an ordinary session court which may be dealing with that. Right. But if it is a child who has committed the murder of another child, it will go to the children's court. And children's court is dealing with is trained to give harsh punishments. So we do not want to, not only they are sent to the adult system, but the whole reformation system in the adult system is also suitable for them. So we do not know, I really do not understand why we are doing what we are doing on the basis of what are we doing. The procedural difference which I wanted to mention was the procedural emergency. Pre-legislative consultation policy of Government of India decided in January 2014 says that if a legislation is making a policy change, that should be put for public consultation for minimum 30 days. This bill was put on consultation for 15 days. Our demand for more time wasn't given. No, 15 days, we have emergency. Then, government is also the ministry concerned, and it is like the ministry is, Ministry of Women and Child Development. It is supposed to be protecting both these sectors, but it is now projecting one sector against the other. The children are the biggest threat to women, not patriarchy, not non-prosecution, non-reporting, bad investigation, all that is not. What affects these women is children. So there is a conflict of interest within the ministry itself. How can the ministry, which is to provide protection to children, be punishing them at the cost of this other sector they are supposed to provide? Article 15(3) in the Constitution says special protective laws can be made for women and children. And I had looked at Constitution today. There's no reference whatsoever to children. And making special laws for children are not mandated barred by Article 15 also. But 15 says no discrimination on basis of sex, and therefore you need a 15(3). But there is no bar on making discrimination on age. We've already done that. 60 you retire, you make a discrimination on the basis of age. At 5 you enter school. At such age you enter such service. You always make discriminatory provisions, differential provisions on the basis of age, and it is not barred by Constitution, but it is rational. Even so, children suddenly came in there because they have always considered children as integral component of being women as well, like content. That there is such a connectivity with women and children. Biological connectivity is a natural phenomenon, and women's relationship with children have been very different. But here is a situation where put it against each other, and then so after 15 days, the Ministry of Women and Child Development sent it to various other ministries for their responses. And they say, give us the response by 8th of August. The newspaper tells us on 6th of August, Cabinet has approved it. We did not have time to wait for the ministries to respond. The ministries are still responding, some of them objecting to it. But we are in a state of emergency. We must do it now, today. We must make this change without looking into the problems that we will be entering in. Thank you very much.
Thank you, Ved, for such a stunning and presentation, which I'm sure has raised many questions, comments. The floor is open for discussion. We take 2 or 3 questions at a time. Yeah, there's a question there.
Ma'am,